Batson versus Kentucky, a failed compromise addressing the conflict of inequality in the United States judiciary system. The United States has overcome substantial challenges to establish equality in our country. Many heroes demanded change from the government during the time of slavery and segregation. One man, a convicted criminal, hardly a hero, brought the United States judiciary system closer to racial equality. James Batson challenged the government to treat minorities fairly during the jury selection process. Peremptory challenges, a long-standing legal tradition, allow attorneys to dismiss potential jurors without reason. A conflict arose in the case of Batson versus Kentucky when the prosecutor uses peremptory challenges to remove all of the African Americans from the jury pool, prompting Batson, an African American, to appeal. The U.S. Supreme Court determined that the jury was biased and attempted a compromise by instituting the Batson challenge. However, the compromise failed to sufficiently protect the rights of minorities. Our Sixth Amendment guarantees a defendant an impartial jury. Yet critics argue that the jury selection process isn't doing the job it is meant to do. The most controversial part of the jury selection process is the use of peremptory challenges. Peremptory challenges, which are limited by state, allow the parties in a case to remove potential jurors without reason. The legal tradition of peremptory challenges dates back to Roman times and has always existed without question until the 20th century. Peremptory challenges are not in our Constitution, but are believed to be a good way to achieve a jury that will decide a verdict based on evidence and not biased agendas that potential jurors may have. Since it is difficult to find enough evidence to remove a juror for cause, peremptory challenges are an important part of our judiciary system. However, critics argue that lawyers use their challenges to get jurors on the panel who will favor their side of the case, leading to inaccurate verdicts, a waste of court resources, and a negative perception of the jury system by the community. There have been multiple Supreme Court cases involving jury selection rights. Swain v. Alabama and Batson v. Kentucky were cases heard within about 20 years of each other, but with different verdicts. In 1965, Robert Swain, an African American, was accused of raping a white woman in Alabama. The prosecutor in his case removed all of the African American people from the jury pool, 2 for cause and 6 using his peremptory challenges. Swain was convicted and sentenced to death. He appealed his case, and the United States Supreme Court stated that there was no way to prove that the challenges were used based on race. Therefore, Swain's rights were not violated and his conviction stood. The social and political ideas changed in the 20 years between Swain and Batson. The dismantling of segregation and legalized racial biases led to the different verdict 20 years later. In 1985, James Kirtland Batson, an African American, was arrested and put on trial for burglary and the receipt of stolen goods. On the first day of trial at the Jefferson Circuit Court in Kentucky, the judge conducted voir dire examination, dismissing jurors for cause. There is no limit for lawyers to remove potential jurors for cause. After voir dire, there were 4 African Americans still in the jury pool. When the judge allowed both parties to use their peremptory challenges, the prosecutor used his challenges to dismiss all 4 of the African Americans from the jury pool, leaving Batson with an all-white jury.
Told you can't object to this. So what do you mean you can't? You work for me, you do what I say, you object anyway. I don't care if it's a long-standing rule. Object. And he did. And it all came behind that one objection.
Batson claimed his Sixth Amendment rights and Equal Protection Clause of the 14th Amendment rights were violated. The Sixth Amendment states that a defendant has a right to an impartial jury. Batson claimed that the prosecutor dismissed the African American jurors to create a racially biased jury. The Equal Protection Clause of the 14th Amendment states that all people have equal protection under the law, and no state can deprive anyone of life, liberty, or property. Batson thought that he was being tried unfairly, with his race being used to leverage a verdict the prosecutor wanted. The Jefferson Circuit Court found him guilty, but Batson was determined to expose the conflicts and injustices of the judiciary system. He appealed his case to the Kentucky Supreme Court, but they too found Batson guilty. He decided to appeal his case one more time to the U.S. Supreme Court. They accepted and heard the case on December 12, 1985. The verdict was decided on April 30, 1986. The justices voted 7-2 in Batson's favor, making him a free citizen. Brennan, White, Marshall, Blackmun, Powell, Stevens, and O'Connor were the justices in concurrence with Batson. Berger and Rehnquist were the dissenters against Batson. Supreme Court Justice Marshall, who sided with Batson, claimed that the court should eliminate peremptory challenges altogether because prosecutors are free to discriminate against minorities. Chief Justice Berger disagreed, stating that peremptory challenges are a legal tradition we shouldn't change. A compromise was struck to address the conflict of racial bias in jury selection. The outcome of this case instituted the Batson Challenge, which affects all trial lawyers in the U.S. If a defendant thinks a prosecutor dismissed jurors based on race, he or she can challenge, and the prosecutor must give a race-neutral reason for dismissing the potential jurors.
The Supreme Court gives very wide latitude to the prosecutor. Really, all the prosecutor has to do is make a claim that's not based on race.
The flaw in this compromise is that the framework of Batson is inadequate. A prosecutor can give any race-neutral reason when his or her peremptory strike is challenged. Unethical prosecutors could lie and give false reasons for dismissing those potential jurors, creating unfair juries towards minorities and violating their rights.
I'd like to see the pathway in Batson to, no, that wasn't a racially motivated strike, tightened up.
The whole system relies on the premise that a prosecutor will look past self-motivation and subconscious biases. Even though racism is no longer socially, morally, or legally acceptable, subconscious and unintentional racism complicate jury selections. After the verdict of Batson v. Kentucky came out in 1986, manuals and seminars were given to prosecutors on how to get a jury that will favor their side of the case.
Let's say you strike 3 blacks to start with, the first 3 people, and then it's like the defense attorney makes an objection saying that you're striking blacks. Well, you're not going to be able to go back and say, oh, yeah, make something up about why he did it. Write it down right then and there. I'd write it right in my little box there, and question him, say, well, the woman had a kid about the same age as the defendant, and I thought she'd be sympathetic to him. In my experience, young black women are very bad. There's an antagonism, I guess maybe because they're downtrodden on 2 respects. They got 2 minorities, they're women and they're blacks, and so they're downtrodden on 2 areas, and they somehow want to take it out on somebody, and you don't want it to be you.
Since Batson v. Kentucky, the court system has further examined the jury selection process. For example, Georgia v. McCollum in 1992. In this case, 3 white individuals were accused of assaulting 2 African American men. During jury selection, African Americans were dismissed with peremptory challenges from the defense counsel. In Georgia v. McCollum, the Supreme Court stated that the jury members' rights were violated, and that jury selections such as this undermine the integrity of the judiciary system. In J.E.B. v. Alabama ex rel. TB in 1994, a mother was trying to get child support from the child's father. In the jury selection, all of the men were struck from the jury pool, creating a gender-biased jury. The Supreme Court ruled the jury selection in this case unconstitutional. These cases ruled that defense attorneys are also held to the same standard as prosecutors and expanded the Batson challenge to gender. In 2013, in the state of Washington v. St. Cali, the state Supreme Court, while still upholding the conviction, stated, the Batson procedure must change as to deal with unconscious, institutional, or unintentional racism. When the Supreme Court was faced with the conflict of racially biased juries, they attempted a compromise with the Batson challenge, but the compromise failed to truly protect the rights of minorities.